Hello, and thanks for tuning in to Look Up Hate Speech Bill Special from Compass Media. I'm your host, Finbar Padraig. I'm joined by Padraig O'Mwany, one of my co-hosts on Look Up every week, and we're going to go through the hate speech bill that's proposed, that's gone through the lower house of the Houses of the Oireachtas in Ireland, and is now going through the Seanad to be presented eventually to the President for signature. It's created a lot of furore and a lot of talk in Ireland, this new hate speech legislation bill. A lot of people are getting worked up, and yet they haven't gone through it themselves, haven't had the time to go through it themselves yet. So one of the key objectives of this specific programme is to go through the text of the bill in some detail so that people can make up their own mind what they think about this bill that is creating so much controversy. Thanks for joining us this evening, Padraig.
No problem, Finbar. Yeah, a very, very interesting one, a very important one I think needs to be covered.
Yeah. So we're going to look at some of the mainstream headlines from Ireland over the last few days and what their interpretation of the bill is for a start. And they all seem to be pretty positive about it. Here's a headline from the Sunday Business Post. This is from the Sunday Business Post. It's about the ICCL, the Irish Council for Civil Liberties. Liam Herrick, ICCL fully supports freedom of expression and has been advocating to ensure this bill properly protects this right. Picture Chris Bellew, Fennel Photography. A civil liberties group is seeking changes to the government's hate crime bill to deliver stronger protection for people's constitutional right to freedom of expression. I'm not sure if the ICCL are saying that they have achieved that or not, because when we go through the bill, we can see that there needs closer and tighter definition in certain areas, and as well as that, the premise of the bill itself appears to be quite flawed. The Irish Times is going all pro this bill in terms of the protections that it's claiming the bill actually gives us. Let's have a look at this. Hate crime and speech legislation to protect freedom of expression. Bill affords robust safeguards for artistic and political discourse and offers ways to deal with offensive online content. So we're going to look now in a few minutes and see, are there really robust securities there for people in terms of their right to expression and right to speech, and not just their right under the law, which may in fact be limited, but their right in general, their moral right to participate in discussions without people saying they're offended and then being shut down and through this bill actually criminalised. The Euronews ran with a headline, New Hate Speech Laws Pick Up a Storm in Ireland. So they're just going over the fact that there has been some political discourse, and believe it or not, there are those from what might be called the liberal left camp and those from what might be called the conservative right camp, who are both concerned about this bill and its impact on the freedom of speech and freedom of expression. So we're going to get stuck into what this bill is all about, if that's okay with you, Padraig.
Yeah, 100%. Yeah.
Okay, so let's have a look at this. So this is the opening of the bill and the purpose of the bill. It's an act to amend the law relating to the prohibition of incitement to violence or hatred against a person or a group of persons on account of certain characteristics, referred to as protected characteristics, of the person or the group of persons, and to provide for an offence of condoning, denying, or grossly trivialising genocide, war crimes, crimes against humanity, and crimes against peace, and in doing so, to give effect to Council Framework Decision 2008-913-JAH on the 28th of November 2008. So that's what the bill is about. It's about the prohibition of incitement to violence or hatred on account of certain characteristics. And we're going to look at the definition of those characteristics in a few minutes. But what people are not talking about is that this bill also censures conversation to a degree, or potentially censors conversation around discussion on genocide, on war crimes, on crimes against humanity, and crimes against peace, which seems like a very loose term. So we are going to look in more detail about what that means in a few minutes after a few other slides. The definition of hatred means hatred against a person or a group of persons in the state or elsewhere on account of their protected characteristics or any one of those characteristics, and we'll look at those in a minute. A word or expression that is used in this act and is also used in the framework decision has, unless the context otherwise requires, the same meaning in this act as it has in the framework decision. So looking at what these characteristics are, In this act, other than in Section 8, protected characteristics in relation to a person or a group of persons means any one of the following, namely race, colour, nationality, religion, national or ethnic origin, descent, gender, sex characteristics, sexual orientation, or disability. In this act, in relation to the protected characteristics, references to religion include references to the absence of a religious conviction or belief. Reference to descent includes references to persons or groups of persons who descend from persons who could be identified by certain characteristics, but not necessarily all of those characteristics still exist. References to national or ethnic origin include reference to membership of the traveling community. So that's quite a wide range, and we would be used to discourse and agreement on discussions of race, color, nationality, religion, etc. But this issue of gender or sex characteristics and sexual orientation and things like this brings in a new character to the discussions on hate speech quite often, especially the gender and the sex characteristics. Gender means the gender of a person or the gender which a person expresses as the person's preferred gender, or with which the person identifies, and includes transgender and a gender other than those of male and female. Sexual orientation has the same meaning as it has in Section 2.1 of the Equal Status Act 2000. Reference to sex characteristics shall be construed as references to the physical and biological features of a person relating to sex. And disability has the same meaning as it has in Section 2.1 of the Equal Status Act 2000. So you can see this is introducing this whole new transgender culture and giving protection in terms of how we speak about it. Protection to people who would be in favor of it. I can see how people would be easily insulted. I've seen so many videos of people who claim to be transgender who seem to get very excited and very worked up and very easily insulted when people try to have a rational discussion with them. So if you look at F there, is that reference to people who claim to be male or female but don't have a womb or don't have some of the sexual organs and sexual parts required to be understood as biological male or female? What do you take from this, Padraig?
Um, so far what we've looked at and the general idea, like you can have a great kind of understanding of the need generally in society to promote equality and to oppose discrimination. I think most of us would agree with that as an outline, you know. But we probably do realize that to get so granular, to get down to specifics, in a way that is dressed up in an awful lot of ambiguous language, as into how to define the offences or potential offences. It really is quite a difficult thing to do fairly. So, like, certainly, like sections of society that are deemed to be minorities do require protection, generally because of what can happen in terms of victimization. And hey, it can be a thing, but to just totally discard what we've already got in place, which would be hate speech laws, incitement to hatred, which I believe probably offer good protections, to get down to something that appears to me at this stage, from what you've presented so far, to be extremely ambiguous and to be open to abuse by people bringing complaints against other people, maybe not always in a very true sense, open to abuse by the state because they've given themselves such a wide set of parameters to work within, and really no protection for people who wish to trash out issues and try and progress society by determining what the problems are in society and determining how we come about solutions. So, so far it's quite worrying. I can see an awful lot of people that can fall into an awful lot of problems very quickly on this. Like even just talking about, let's say, things that would be Irish history, for example, and perceptions and of how we view ourselves and view things that have happened in the past, how we identify ourselves. If you cross reference what they're saying here in terms of religion. We've got two predominant religions here over the centuries, both of them Christian, but an awful lot of differences between the two. So even if you apply that particular type of logic and ask yourself, how will this stand up in the future? People's perception of what has gone on before. I see huge amount of questions. I think we really need to go backwards with this and examine it, because we're already at the Shannon stage, Finbar, which is quite worrying.
Yeah, yeah. And we are going to look at the potential constitutional challenges, of which we conclude that they are very limited, I'm afraid. Just looking at further interpretations and application in this part, information system has the same meaning as it has in Section 1 of the criminal justice system. Material means anything that is capable of being looked at, read, watched, or listened to, either directly or after conversion from data stored in another form. A public place means any place to which the public have access, whether as of right or by permission, or whether subject to or free of charge. Reasonable and genuine contribution in relation to literary, artistic, political, scientific, religious, or academic discourse means a contribution that is considered by a reasonable person as being reasonably necessary or incidental to such discourse. We're going to bring up that issue later on, because who defines what a reasonable person is? Who defines what reasonably necessary is? And that's a key issue here. And in terms of looking at other aspects of this law that call into question, they don't use the phrase later on reasonable, but they do talk in that manner, and we can underpin it from or by this interpretation of a reasonable person as being reasonably necessary. Two, for the purpose of this part, a person shall be regarded as communicating material to the public or a section of the public if the person displays, publishes, distributes, or disseminates the material, shows or plays the material, or makes the material available in any other way, including through the use of an information system. That's pretty clear there. The word disseminates. So if you talk publicly about the material, that's disseminating it. So is that a criminal offence? Because there are quite severe penalties under this new bill and this new law that is almost ready to be enacted. For the purpose of this part, a person's behaviour shall include behaviour of any kind, and, in particular, things that the person says or otherwise communicates, as well as things that the person does, and such behaviour may consist of a single act or a course of conduct. So that's all encompassing. Anything that in any way expresses anything, even dance, music, anything, it comes under this law. Offences of incitement to violence or hatred against persons on account of their protected characteristics. Subject to Section 2 to 4 and Section 11, a person shall be guilty of an offence under this section if A. The person 1. Communicates material to the public or a section of the public, or 2. Behaves in a public place in a manner that is likely to incite violence or hatred against a person or a group of persons on account of the protected characteristics or any of those characteristics, and B. The person does so with intent to incite violence or hatred against such a person or group of persons on account of those characteristics, or any of those characteristics, or being reckless as to whether such violence or hatred is hereby incited. And then you have those phrases again, like reckless or being reckless. Is likely to incite violence. So it doesn't actually have to incite violence. It just has to be likely to incite violence. Again, very, very loose wording to my
Well,
mind.
that one there, just to the end of what you're showing there, Finbar, is quite concerning. Like, I'll just read what I've had a look at there. So, it says, if any or those characteristics, or being reckless as to whether such violence or hatred is thereby incited. So, if you're having a conversation and following that conversation, people's interpretation or beliefs of what the conversation actually meant and how it made them feel made them go on later on to commit acts of violence, you're culpable for that. That's what it seems to be saying there. So, like, this really is a problem with freedom of speech, because we could be talking about very emotive things that are happening in the world. It could be um the victimization that's happening in places like Palestine. We could get quite angry about what we know is happening in places like that and how people are being treated. If somebody else then takes it upon themselves after that to commit an act of violence or to promote an act of violence, the original conversation and those who had it are potentially called into question there. So really, really loose.
Yeah. In any proceedings for an offence under this section, it shall be a defence to prove that the material concerned, or insofar as appropriate, the behaviour concerned, consisted solely of a reasonable and genuine contribution to literary, artistic, political, scientific, religious, or academic discourse. A statement that is the subject of the defence of absolute privilege, or material or behaviour, as the case may be, that is necessary for any other lawful purpose, including law enforcement or the investigation or prosecution of an offence. So this is what the court is saying they will accept as a defence, that it was a reasonable and genuine contribution to literature. Again, who decides what is reasonable and genuine? Who decides that? Because they pull out some document or some report that has been published by an organization that's funded by the state or funded from outside the state or funded by lobby groups or has been nurtured by lobby groups. And they say, this is the real evidence. So what you're doing is not speaking about is not reasonable and it's not genuine. So who decides that in the long run? It's very, very worrying. Absolute privilege refers to the privilege of, for instance, an elected politician to speak in the Dáil. If any proceedings for an offence under this section, it should be a defence for a body corporate to prove as respects the communication of material by the body corporate that A, it has reasonable and effective measures in place to prevent the communication generally of material inciting violence or hatred against a person or a group of persons on account of their protected characteristics or any of those characteristics. It was complying with the measures referred to in paragraph A, and it did not know and had no reason to suspect at the time of the offence concerned was alleged to have been committed that the content of the material concerned was intended or likely to incite violence or hatred. So this is the protection for news organisations and things like that, that if they have a policy in place, if that policy is usually implemented, but for some reason something got through this time, and if they can prove that they did not believe at the time that it would incite violence or hatred, that is a defence in itself. But again, to me, it seems quite loose. Any comment on that, Porter?
Yeah, I suppose, and one of the things I would have heard generally is this all seems to be slanted towards the defense rather than, it being proved that you are guilty or potentially guilty of any of these offences. It seems to be that you must prove that you didn't, which is a reversal of what we expect.
Yeah, yeah. In terms of the sentencing for committing crimes, and they are crimes under this new bill, a person guilty of an offence under this section shall be liable on summary conviction to a Class A fine or imprisonment for a term not exceeding 12 months or both. So if you don't put up a defence and you plead guilty and there's no trial, you can be fined up to €5,000 and get 12 months. That's quite severe, and that's when you don't defend yourself. B, on conviction or indictment, to a fine or imprisonment for a term not exceeding 5 years, or both. So this bill is proposing to jail people who defend themselves of this accusation for 5 years if they're found guilty. That's severe to my mind. What do you think, Padraig?
Yeah, well, even those two distinctions between A and B would put people in a conundrum whether they say, the most likely there will be some sort of accommodation decided on where it probably would be a fine. But so take a fine, that's a conviction, and that's a statistic of for the courts to be able to show that there was convictions on this and there was full follow through. When in the case you may actually probably feel strongly that you were innocent, but the severity of the second one is such that people would be really, really maybe inclined to really consider the first one. So why such a big disparity?
It really would prevent a lot of people from defending them. Not only the price of defending yourself, because it's very difficult to get a good solicitor and legal aid. So the price of defending yourself with a good solicitor, and also the threat that if you lose, and we know what the Irish courts can be like, if you lose, you get 5 years in prison and a hefty fine, which I think would exceed 5,000. The inference is there's no limit on the fine that you could get if you're found guilty and you defended yourself. It's pretty severe. Another part of this bill that nobody's talking about and that really, really does concern me is this section here. The offence of condemnation, denial, or gross trivialization of genocide, etc., against persons on account of their protected characteristics. 8. 1. Subject to section 11, a person shall be guilty of an offence under this section if the person A. communicates material to the public or a section of the public, or behaves in the public place in a manner that condones, denies, or grossly trivializes genocide, a crime against humanity, a war crime, or an act specified in Article 6 of the Charter of the International Military Tribunal, where such communication or material or behaviour is directed against a person or group of persons on account of the protected characteristics or any of those characteristics, and is done with intent to incite violence or hatred against such a person or such a group of persons on account of those characteristics or any of those characteristics. That's very worrying for me, Padraig, because it calls into question the right to talk about not just historical, but ongoing political events, military events, when there are powerful forces that propagandize those events and that weaponize the claims of war crimes, the claims of genocide, and things like that. We'll just look at, first of all, what the sentences are for this so-called crime. A person guilty of an offence under this section shall be liable on summary conviction to a Class A fine or imprisonment for a term not exceeding 12 months, or both. It doesn't say what happens to you if you actually defend yourself when this charge is made. And that is glaring to my mind. In the previous penalties that we saw, there was a penalty for summary conviction and there was a penalty for if you defended yourself, and there was a trial. It doesn't say that here, and I find that quite odd. In this section, an act specified in Article 6 of the Charter of the International Military Tribunal means such an act that has been determined to be a crime against peace, a war crime, or a crime against humanity. How loose is that, as the case may be, each within the meaning of that article by a final decision of the International Military Tribunal. So I actually have that article here. So this is Article 6. The following acts or any of them are crimes coming within the jurisdiction of the tribunal for which there shall be individual responsibility. And remember, this was created in the aftermath of World War II and in the context of the persecution principally of the Jewish people in Europe. A. Crimes against peace, namely planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. War crimes, namely violations of the laws or customs of war. Such violations shall include, but not be limited to, murder, ill treatment, or deportation to slave labour, or for any other purpose of civilian population of or in occupied territories. Murder of ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, wanton destruction of cities, towns, or villages, or devastation not justified by military necessity. Crimes against humanity, namely murder, extermination, enslavement, deportation, and other inhumane acts. I think we get the picture here. As I said earlier, or inferred earlier, I would have a real concern about this, because the issue of war crimes, of war itself, of genocide, have become highly weaponized over the last 2 decades in particular. The Israeli lobby have weaponized it to hide what they're doing, as well as to make accusations that people are anti-Semitic and things like that, when in fact they're actually criticizing the Israeli state itself. So I think that will fall into this bracket. I think issues like, for instance, allegations of war crimes, with the allegations of the gassing of civilians in Syria by the Syrian government, when organizations that are responsible for investigating these things at an international level, when their investigators and inspectors created reports around these allegations, those reports have been proven to have been doctored by their seniors, the people at the top level of those types of organizations. This has been brought out in the case of Douma in Syria, this has been completely revealed and is in the public domain. And I've seen so many other organizations that have been captured and corrupted by special interests, whether it's the US military, whether it's British intelligence. And so this is the evidence that is used to underpin war crimes trials. We also see the issue of the issuing of arrest warrants for Vladimir Putin and the Russian ombudswoman for children on the claims of war crimes and the kidnapping of thousands of children whose parents actually sent them to Russia to avoid the war. And we see the ICC, which is the latest development since 1945-46 in terms of international war crimes and how procedures are in place internationally to bring people to justice. I think that if the likes of myself and yourself, Porter, have discussions on these kind of allegations that we believe are being, or I believe are being weaponized, that we would fall within the remit of this law and that we could be charged and found guilty. We could be sent to prison for 5 years if we defend it, well, 12 months in this case for this particular section of the law, but in other sections up to 5 years and a hefty fine. What's your take on this specific article within the bill that's covering war crimes, genocide, things like that?
It's extreme, and like it's ironic that what is referring us to here is the United Nations Treaty. What that set out to do was to prevent a reoccurrence of a genocide, and try and explicitly call out sections of it that would constitute that, and here we are now having it weaponized against us, which is the irony, because what we would seek to do is to be objective, source material which is well founded, and put it in the public domain for public discourse to ask the questions of power, of what is acceptable in our name, because we're a country that's, let's be very honest about it, we're subordinate to bigger power structures. And us as individual citizens, we believe we're living in a democratic state, and we believe when we elect representatives to go to different houses, whether it be within Ireland or in the EU, that we have a level of freedom, and that we should look out upon the world in a progressive way, where we would hope no harm that maybe has happened to us down the centuries will be happening elsewhere. So we have a big requirement on us to speak out, and I think this is tied in with our neutrality and stuff like that, as well as the humanitarian element of what goes on in the world. Ireland has traditionally had a strong position on all of that. We're going to be restricted now from looking objectively at these things, and trying to get debate, and trying to get genuine investigative journalism to occur, and get our representatives to ask these questions of power. All of that is under threat now with this,
Yeah,
and
yeah,
it's extremely concerning.
it is concerning. And the more I look at it, the more I focus on the potential abuse of these laws by the state, by powerful agencies inside and out of the state, by lobby groups, things like that. It's very, very worrying. The next section of this law looks at, for both section 7 and 8, looks at if you're accused of these things, even if you didn't actually incite hatred or things like that, can you still be guilty? A person may be found guilty of an offence under section 7 or 8, irrespective of whether the communication of material or behaviour, the subject of the offence, was successful in inciting another person to violence or hatred against a person or a group of persons on account of their protected characteristics or any of those characteristics. Subsection 3, in any proceedings for an offence under section 7 or 8, where it is proved that the person communicating the material concerned knew that what the material contained, understood the meaning of the material, and made the material available on a platform that is or may be accessible by the public or a section of the public. It shall be presumed that the person intended to communicate the material to the public or a section of the public. In any proceeding for an offence under section 7 or 8, an accused person may rebut the presumption raised in subsection 2 by showing at the time of the alleged offence that he or she did not know the material communicated would be made made available to the public or a section of the public. That's a very hard thing to prove, isn't it? That you didn't know that this was going to be made available to the public. What if you had were preparing something for a private conversation and that other person shared it? You know, how can you prove that it wasn't my intention that other person shared? So there's a lot of difficulties in this, Padraig. We'll move on to the next section, offensive preparing or possessing material likely to incite violence or hatred against persons on account of the protected characteristics. And this has raised a lot of eyebrows. The idea that you don't have to have shared something. You can have just something in your possession. Could be private thoughts, but you could be accused that those private thoughts were preparation for publication in some way. So section 10, subject to subsection 2 and 3 in section 11, a person shall be guilty of an offence under this section if the person A, prepares or possesses material that is likely to incite violence or hatred against a person or a group of persons on account of their protected characteristics or any of those characteristics with a view to the material being communicated to the public or a section of the public, whether by himself or herself or another person, and prepares or possesses such material with intent to incite violence or hatred against such a person or group of persons on account of those characteristics or any of those characteristics, or being reckless as to whether such violence or hatred is thereby incited. There's a little bit to unpack there. So you don't have to, under section A, you don't have to have published this in any way. You just have to have this in your possession. And even if somebody else publishes it, you're in trouble. What do you make of this?
It's amazing to see this text actually stand here as something that has gotten through the fourth stage of the Oireachtas, which through the Dáil, it's obviously been drafted by legal professionals, been probably looked at by the Attorney General, and here we are at the latter stages of ratification, and it's so ambiguous and it's so wide ranging. It really, really, it's quite amazing.
In terms of further defences and protections and things like that, if any proceedings for an offence under this section, it shall be a defence to prove that the material concerned consisted solely of a reasonable and genuine contribution to literary, artistic, political, scientific, religious, or academic discourse. And remember the problem we had with who decides what reasonable is, who decides what a genuine contribution is. A statement that is the subject of the defence of absolute privilege, again, politicians, sometimes journalists, things like that, in the courtroom, material that is necessary for any other lawful purpose. If in any proceedings for an offence under this section where it is proved that the accused person was in possession of material such as is referred to in subsection 1, and it is reasonable to assume that the material was not intended for the personal use of the person shall be presumed until the contrary is proven to have been in possession of the material in contravention of subsection 1. So this is the presumed guilty aspect that people are really getting upset about as well. And it seems to be creating a bit of a precedent in Irish law that you're presumed guilty until you prove your innocence. How can you prove what your intention was in writing something down, for instance, in a detailed fashion? A person guilty of an offence under this section shall be liable on summary conviction to a Class C fine, so a much smaller fine, or imprisonment for a term not exceeding 6 months, or both, which is quite a hefty prison sentence all the same, 6 months out of somebody's life. Or B, on conviction of indictment, this is where you actually defend yourself, to a Class A fine up to 5 grand again, or imprisonment for not exceeding 2 years. So if you defend yourself, even if you haven't published anything, if they prove to a judge in some way with a very low bar of proof, if they prove to a judge that or convince a judge that you intended to get this out into the public domain in some way, and you defend yourself, you can be fined up to 5 grand and go to prison for 2 years. The severity of it just is astounding, Padraig, isn't it?
It is indeed, yeah. The practicality of it just doesn't seem possible to me really, and I don't think the implications of it are fully understood because this hits every section of society, and as we know, there are different tiers of society in terms of how people are treated when it comes to the law. So if you're in a position of some privilege, maybe within political circles, maybe you may not be treated as badly. That's there to be seen if that's the way people interpret things. But I mean, in the era of digital recording, we're talking about phones in pockets. Like, have they understood the scope of what they're saying? Because you only need to record a conversation, and if it's somebody in the public eye that's been recorded, it's going to go viral very quickly. And what does that mean then? They had the conversation, so they're the ones that's guilty. The person who's distributed it is probably guilty. I really don't think they've thought about the practicality of all this.
Yeah, yeah. And how this can be so open to abuse, and these allegations can be made. And when the state is taken up by a kind of a zeitgeist, kind of a trauma almost, where people are going crazy and attacking each other, accusing each other of being fascists and Nazis and this and that, and that kind of an atmosphere, that uh, that heated up atmosphere, I can see these laws being significantly abused. The Irish Times headline that we introduced this program with uh, really advocated the idea that there were protections for free speech in this new bill. But there seems to be only one section dedicated specifically to that. And here it is: protection of freedom of expression. For the purpose of this part, any materials or behavior is not taken to incite violence or hatred against a person or a group of persons on account of the protected characteristics or any of those characteristics solely on the basis that the material or behavior includes or involves discussion or criticism of matters relating to a protected characteristic. That sounds like it's giving you protection, but I'm not sure about it, because I keep on trying to, or keep on recalling that whole word reasonable. And then I read this again: solely on the basis that material or behavior includes or involves discussion or criticism of matters relating to a protected characteristic. That's very loose. Doesn't even use the word reasonable there. But I can see the judge applying the concept of, well, what is a reasonable criticism? What is a reasonable discussion on this issue? Some academic been called over from the United States to give evidence to say that, you're complete anti LGBT rights if you question anything for a second on the issue that they are promoting. And I've seen them doing that in the United States Senate, where when a guy asked a question, they actually jumped down their throat accusing them of being essentially fascists. And he was just asking a question. So their tolerance for offences is very low. And when I look at this so-called protection, there's only paragraph or only section that's dedicated to protection of freedom of expression, and it's only one paragraph of 4 lines. I think it's, again, very loose, and that word reasonable that has been used in previous sections will be introduced if a judge wants to make a decision on this particular section. Do you think that's adequate protection, Porter?
I don't, Finbar, but I think that section there, albeit how small it is what makes it appear to be constitutional, because the Constitution gives you this freedom of expression, and they've made reference to it here, in a very vague manner. But this is probably how they will protest its constitutionality.
Yeah. And we're going to look at that just at the end of the program. We're nearly through this, folks. We're just going to look at a couple of other issues: the jurisdiction, search warrants, things like that. In terms of the state's jurisdiction to enforce this law, in any proceedings for an offence under section 7 and 8, where the offence was committed by a person using an information system, the offence may be prosecuted as an offence committed by the person within the state. If the person was in the state when the offence was committed, whether or not the offence involved material hosted on an information system in the state. Or B, if the offence involved material hosted on an information system in the state, whether or not the person was in the state when the offence was committed. So I think what it's saying is that if something is shared from outside of the state and is held on any type of information system at all in Ireland, that will be committing the offence, even if the person has published it from outside of the state. So again, it's quite loose. Are authors who didn't intend something to be published in the Irish Republic, are they guilty because somebody shared it in Ireland? if they ever put their foot down at Dublin Airport on the tarmac, are they likely to be arrested, even though they had no intention of it being published in Ireland? Padraig, your thoughts?
Yeah, well, in the age of social media, I do know of a few prolific accounts um, that reside outside the state, which originate with people who were native of the state, and their opinions are in some cases can be quite revealing against sections of the state and things that are going on. Um, so it kind of seems to me that like they haven't forgotten that there's a few troublesome accounts out there maybe, and so they're just making sure the extension goes all the way to make sure everybody is caught in the brackets of this. Like,
Yeah. And also threatening people from that live outside the state as well, in terms of publishing things that you won't be able to come to Ireland potentially, if our understanding of this is correct. In terms of search warrants, the issue of search warrants have created some upset as well. If a judge of the district court is satisfied with information on oath of a member that there are reasonable grounds for suspecting that evidence of or relating to the commission of offence under section 7, 8 or 10 is to be found in any place, the judge may issue a warrant for the search of that place and any persons found at that place. A search warrant under this section shall be expressed and shall operate to authorise a named member accompanied by such other members or persons or both as the member thinks necessary, so that's members of An Garda Síochána, to enter at any time within 1 week of the date of issue of the warrant, on production, if so requested, of the warrant, and if necessary by the use of reasonable force, the place named in the warrant, to search it and any persons found at that place, and to examine, seize and retain anything found at that place or anything found in possession of a person present at that place at that time of that search, that member reasonably believes to be evidence of or relating to the commission of offence under section 7, 8 or 10, as the case may be. The authority conferred with subsection 2C to seize and retain anything includes, in the case of a document or record, authority to make and retain a copy of the document or record, and where necessary to seize, and for so long as is necessary, retain any computer in which any record is kept. A member acting under this authority of the search warrant under this section may operate any computer at the place. So this is giving very broad permissions and facilities for the Garda Síochána to raid premises and raid homes where they suspect, without having to produce any evidence, just suspect that somebody might be writing something that might be offensive, essentially, or might in some way lead somebody else to feel hate towards somebody else, or a group of persons, or those other characteristics such as transgender, etc. Again, this is really showing the criminal law aspect of this bill, isn't it? And again, the abuse that it just takes a member of An Garda Síochána to whisper in a judge's ear that he thinks, and how this can be abused into the future. What do you think, Padraig?
yeah, well, it's quite draconian. I think you'll find draconian legislation like this exists around prescribed organizations and stuff. And you've seen it in use in those terms. So you're looking in terms of severity of what they can apply to things that they have in the past deemed to be a threat to the state. And this is now something that is speaking in similar language that's being brought in for just the general public. So I suppose it really is a major departure, and it begs the question, which I've, I suppose, been pondering on, that like what is the major issue with the current hate speech legislation that they have, like the incitement to hatred. That I can think of a number of cases where seem to be quite effective at nullifying what I would probably agree was hate speech. Um, and why such a big departure and such an all-encompassing piece of legislation? It's very strange altogether, and it's continues to be worrying. Every section that you read, it opens up more and more civil liberties issues to me.
I think that the two core thrusts of it is to enforce this new trans culture and this new self-identity culture that has developed. And the second part is to please the Israeli lobby and US militants and EU Atlanticists who advocate for war, and so I suppose the military-industrial complex in both the EU and the United States benefits from this legislation. So I can see those trusts as being key to the additions. And one of the final sections is threatening, abusive, or insulting behavior in public place aggravated by hatred. So the hate speech bill itself also changes other existing laws to add hate as an aggravating factor to an offence that will add extra penalties to that offence. So, for instance, threatening, abusive, or insulting behaviour. Well, if it's now aggravated by hate, the offence is considered to be more serious. And again, we look at what do we mean by insulting behaviour? Who decides what insulting is? Distribution or display in public place of material which is threatening, abusive, or insulting. Again, an aggravating factor now that's being added to that is hatred. And again, this will increase the sentence under that particular law. That's all we have in terms of the text itself and the meanings of the text, and giving you an opportunity to see it, to read it yourself, and to react to it yourself. We have a couple of videos here, as we said earlier, from what might be deemed to be the two opposite or opposing ends of the political spectrum in Ireland. Ronan Mullen, who may be considered conservative, and on the other hand, Paul Murphy, a member of People Before Profit, who may be considered to be a left, liberal, or woke kind of a guy in some ways. And both of them are pretty upset by this legislation. So we're going to look at what the two of them have to say, and we'll come back in a little minute.
We live at a time when there's increasing danger of cancel culture. There is a centralisation of power. There's a very real desire among people in power, and not just in Ireland, to interfere with people's natural and legitimate freedom to express ideas, even robustly. To listen to Barry, you would think that there were no laws governing insulting and abusive behaviour. You would think that there were no public order offences. You would think that there were no... I was in a taxi earlier on today, and the driver said to me, you know, I was recently abused and threatened by the guy in my car. And in fact, when I went the following day to complain to the Gardaí, they said, well, did he touch you? No. Oh, well, then we can't do anything. But in fact, there are laws there to deal with that kind of threatening and abusive behaviour. So if we could get the Gardaí actually applying the laws that are there, that would be a good thing. But the government interfering and trying to put a chilling effect, and it's not on people like me. I'm a politician, so is Barry. We have privilege, we can say what we like in the Shannon, and we probably have brass necks as well. It's the ordinary person who's maybe not as skilled in debate. There's a chilling effect on them expressing their legitimate point of view, whether it's right or it's wrong on issues of concern.
But isn't there a difference, Ronan, between...
Section 10 creates the possibility of someone being criminalised purely for having material which is hateful, without that material being communicated to the public. That's a problem, in my opinion. Like that it gets to the fundamental problem of this bill. That is the creation of a thought crime. Someone has hateful material on their computer. They don't publish it. No incitement to hatred is caused. There's no consequence for anybody else. The person themselves has hateful ideas. They write hateful things to themselves. They download hateful material, whatever, and they can be criminalised as a consequence of that. Again, to be clear, I'm against this hypothetical hateful material that this person has on their computer, but I think it's extremely problematic to create this new category of thought crime, of preempting the incitement to hatred and the propagation of hatred ideas. And as a part of that, I mean, subsection 3 states that where it is reasonable to assume that the material was not intended for personal use, the onus will be put onto the accused to prove their own innocence by showing the material that they prepared, or even just material they possessed, was never intended to be publicly communicated. And so within Section 10, you have the creation of thought crime, and then you have a dangerous reversal of the burden of proof, where the burden is now placed on the accused to show that, to overturn the presumption that the material was not intended for personal use. This is extremely problematic. There is a real problem in terms of civil liberties with this section. As I understand it, at committee, the Minister argued that, don't worry, the DPP won't be taking cases willy-nilly, be very sensitive and so on. That That can't answer to us as legislators. We're creating law. We don't control what happens after that, and we can't be satisfied by promises that the TPP will or will not do something, nor can we be satisfied by promises that the courts will or will not do something.
So that was Senator Ronan Mullen, an independent senator, and Paul Murphy, TD. What do you make of what they have to say, Padraig?
Yeah, both have validity in what they're saying. Like, we should never have a situation where we introduce something that's going to be abused or misused. And as much as protections in society, I would advocate 100%. I'd like to see no scapegoating of any minority in society. But I don't think that this is a practical bill. I don't necessarily believe I even understand why it's necessary. I think existing legislation covered adequately, I believe. There are instances of people being discriminated against online, but no more so than people that were scapegoated during the COVID period. And I note that there is no provision for people like that within the specified minorities. So, and there was a lot of hate speech, in my view, against people who weren't vaccinated. You know, people who had an issue with foregoing their own right to bodily autonomy. And in that context, why are they excluded from it? Because we could quite easily see another period, and it was definitely hate speech you were seeing against some people, like, you know. So if you're going to do it, like, do it across the board. Be fair, be consistent. Don't discriminate against some people and not others. Like, I think the whole ethos behind this isn't set up properly either.
Again, I have to maintain that I believe this is about criminalizing resistance to new isms and new ideologies that are developing, and new so-called causes that are developing. For instance, this whole thing about you deciding your identity yourself, you deciding your agenda, and things like that, and your identity. And on the other hand, this issue of trivializing war crimes and genocide. I think this is really weaponizing war crimes and criminalizing conversations that don't go along with NATO and don't go along with things like that. And the Israeli lobby, I can clearly see that happening. Padraig, you just mentioned in terms of politicians, we don't have the video on hand for this, but that Gripped Media asked Leo Varadkar some questions about the hate speech bill. What have you got for us on that?
Just viewed the video, and a very direct and straight question was asked on public opinion around this, and public opinion in the form of polls indicated there wasn't support for this bill. And listened to Leo Varadkar explain how public opinion polls aren't necessarily that reliable, and that it doesn't necessarily constitute the will of the people. It's not being properly tested. So he took them, but it was put to him that well, why take it if you're not going to listen to the findings of it? And this is how he explained that it's not conclusive in his view. So public opinion in a democracy being sampled in a very small scale, it's not conclusive. I would 100% accept, but he was kind of dismissive in his answer, which is poor, really poor, like, for somebody in high office.
Public opinion doesn't seem to particularly matter to them. In terms of what people can do about this bill, I've heard a lot of people saying, well, it's going through the Senate and it has to go to the president, and they can send it back for a period of time for it to be reconsidered. The president can question its viability in terms of, is it constitutional? And this big issue of whether this is constitutional, whether it oppresses our freedom to expression within the Constitution, may be a red herring, because the Constitution's protection and freedom of expression is actually quite limited. And we'll just have a look at that now. Okay, so this is section 40.6 of the Irish Constitution, Bunrock na hÉireann. The state guarantees liberty for the exercise of the following rights, subject to public order and morality. 1. The right of citizens to express freely their convictions and opinions. The education of public opinion being, however, a matter of such grave import to the common good, the state shall endeavour to ensure that organs of public opinion, such as the radio, the press, the cinema, while preserving their right for liberty of expression, including criticism of government policy, shall not be used to undermine public order or morality or the authority of the state. The publication or utterance of seditious or indecent material is an offence which shall be punishable in accordance of law. So you can see there are protection to freedom of expression is not as clear cut as you might say. And in terms of the word morality and public morality and things like that and public order, it's very hard to confidently say that the Constitution protects freedom of speech and freedom of expression. And I don't think that, I think the looseness of that section 40.6 is such that this bill could easily be argued to fit neatly with it. What's your take on that, Padraig?
I would have concerns about constitutional challenges anyway, because I don't think you get multiple runs at it. I think when you take one, that's more or less it decided. It goes down as the precedent then after that. So I would be concerned about half-baked attempts at taking constitutional challenges. So but also in reading that, like, it was written in a time of very different social conditions, in that, you know, you're seeing mentions towards morality and stuff like that. How do you define that now? Gone from 1937 to 2023, very, very different probably perceptions out there of how you define morality and what would be on the right side or the wrong side of that. So, I mean, the Constitution, I mean, in the time it was written, it's very, very hard to see how that even applies to this conversation now.
I think there are some crossover applications. For example, I think the rabid atmosphere of the controlling Catholic Church of the 30s, 40s, 50s, 60s, that spirit still exists, but it's in terms of wokeism rather than the Catholic Church these days. But they're still as extreme, and they're still as often as nasty and as suppressive as ever, whether it's the Catholic Church or whether it's just new wokeism that exists and that we're seeing not only in Ireland but globally. Padraig, we're going to close up with this. I would encourage people to like it, share it, subscribe to our platforms where you can. This has been an opportunity to go through the text of the law yourself and to make up your own mind without others filtering it for you, to make up your own mind what you think about this new hate speech legislation. Thanks for joining us again this evening, Padraig.
No problem, Finbar. Yeah, happy to do so. Thanks a million.
Bye bye, folks.